Could you come over here a little bit so I can hear you?
Ideally, the next witness would be Ava Crow, who's the special education expert.
But that's mitigation.
Well, I think it goes to intellectual disability in his statements.
It goes to what?
His intellectual disability.
Well, we've already been through that with your other witnesses.
Right.
That we took all that by avowal.
Right. So, if the court's not going to allow her to testify in the fact phase of the trial, then we'll recall her for mitigation. But we still probably will need to get that by avowal because she'll be out of the state for like the 15th through the 23rd.
Do you want to release the jury and to go ahead and do her now?
We could do that now. The only other witness I think that we have waiting is the grandmother, and I don't think she's going to add much in the guilt.
Well, if we've got a fact witness, let's do them. If we've got a
we
fact
can call
witness.
Edith for like a couple little things, and then maybe do the Ava stuff. I just kind of wanted to sort out
How many do you think you'll have tomorrow?
Jessica's going to have to testify, and like 4.
We can't do any others tonight?
She said,
One's being transported
grandma?
tomorrow. Yeah, we can do grandma.
Grandma,
we
and
can do
then why don't we do grandma, release the jury, and then do woman for the special ed.
And how many tomorrow?
4 is my plan.
And who would that be? Well, I
Well,
need it.
Weedman was transported. It's the big Sandy guy. And the other 2, Marvin LaFleur, who was the sheriff, and Cleo Powers, we had just told we thought we'd get to them tomorrow.
Okay.
And then Jessica, who's with us now or later, she's our investigator, so she's got some stuff to talk about.
Well, if there's that,
Jessica's here.
we may be able to.
She is, but there's a couple things.
Okay,
Well,
she
we can get to
testified.
her.
Let's get to her today. Let's do everything we can today with fact witnesses.
Yes.
Yes, she's been in the courtroom all the time.
So,
Let's do all the fact witnesses we can get to today, and then we
I
can
wanted
discharge
her
the
to wrap
jury.
up after all of the witnesses, but that's just how we'd like to call our witnesses in that order. I would like for her to be last.
I think that we need to call the witnesses in the order the defense prefers, Your Honor.
Yeah.
So could we go at, but having said this,
And Ava,
sounds
could
to me
release
like
the
we're
jury
going to be able
after
to
about
rest
10,
tomorrow
15 minutes.
For the defense, and we're going to be able to give this to the jury tomorrow. So let's get this grandma in here, my suggestion, of course, and then let's get special ed in here, and then we'll go for the 4 tomorrow. Is that
All right,
the way?
now.
Is that the way you want to do it?
That's what I want.
That's what we would
And,
request, because it's defense's request.
Is your people? Are you working on instructions?
Yeah, I think ours are probably done, but
All
I can't tell
You got
that
the
for
email?
sure.
You don't plan to call anybody on
Because
the
you can take your laptop home,
Okay.
and then you can have it
Yeah,
tomorrow.
all right. Okay. All right.
But if we get this woman in here, we can get this jury out here by like 4:30 or 4:15.
Okay, let's do that then. The grandmother's gonna be short.
She'll be short. She's hard of hearing. She may need the headphones.
Okay. Okay, all right. Okay. We're-
Grandma was, I'll wait for them.
Okay.
Grandma was a very minor witness, and she's not having a good day,
Mm-hmm.
and she's gone. So we're not going to use her. We're not going to
Okay.
call
She
her.
was.
All right.
She was here earlier.
Mm-hmm.
I don't think it. We don't want to call her tomorrow.
Okay.
We have
Okay.
some stuff for mitigation that's on record already, so we don't need her to be totally here.
We knew she might have some health
His grandmother or
issues.
his
His
grandmother?
Yeah.
His grandmother.
So we have an affidavit from her
So-
for mitigation just in case.
What I was
We-
going to say
we
is
don't
if we
really
could
have
go ahead and
no
release the jury,
Yeah.
Release the
and we'll do
jury.
Ava now.
I thought she might be able to testify today. She's
sorry.
getting
How
here.
long will the eval take, do you think?
Well, I think it's mitigation evidence is what we're doing now.
Yeah, that's what I mean.
But
Part of
it
it
shouldn't
is
take too
bringing
long.
in-
Yeah, it,
Oh,
we're
yeah.
taking medication evidence out of
So
order.
we're
We
releasing the
recognize
jury.
we're only
Yeah.
gonna put in the avowal
It's-
because our
It's
request to
going
have her
part
testify
eval
in the
and
fact
then
case
part
has been overruled.
mitigation, because
Gotta
you may have to go to
get out.
Colorado.
But yeah, but you could probably free the jury.
But then I think tomorrow it wouldn't take, we don't have that many witnesses tomorrow. It
So
will,
like noonish?
yeah,
Okay.
well,
And then and we're planning, they're planning on giving this to the jury at noon tomorrow.
Good.
So,
Well, we gotta close it.
well, close
How about
it.
lunch?
Close
Close it.
Yeah, I agree. So we're gonna release the jury today and then do this eval? Is that
that's what
right?
that's what I would prefer.
I've got to see some instructions and then work on it tomorrow.
Judge,
Well,
we
Coach has been working on
been
this whole
working on
last
it all day.
couple
On
hours.
the charges.
We have them on email, we just haven't looked.
Okay, now when you said you email them, who are you going to email them to?
We'll email
How
them
do
to you
you
if you
want
want us
them
to.
to?
Well,
Who do you want us to email them to?
you
We
give,
can connect your laptop
We,
to the Wi-Fi.
we were originally gonna email them to Gloria,
yeah,
but if you want them to you, but, we have them on email that we can send,
And
but
if you want them at your house, Your Honor.
who did you get? What email address did Colby give you?
Gloria's.
Gloria's. Let's just keep the stamp, let's go with that
Okay.
and get them on in and yeah, I'm going to be out of it tonight by the time we get through.
Okay.
Yeah.
So,
Well, let's go ahead and release the jury and then get done with this eval.
Okay, all right. Ladies and gentlemen, we're going to let you go for the evening, and we will see you in the morning. And about 10 to 9, same as this morning. Please, same admonition. Please don't form any opinions yet, because all the evidence isn't in, and don't discuss any of this with anyone, among yourselves or anyone else. If anyone approaches you about it, please report back to me. As I've said every day since we've been here, don't watch WYMT. I pick on the, we're lucky to have a great region news, but don't stay off the news and stay off Facebook and social media and things like that. All right, thank you all, and we'll see you in the morning. All right. Honor or Ms. Camp, the witness we're getting ready to call to stand in a moment is part by vow and part mitigation. Is it all the same though?
It is in,
I would say the report and the review of records and that content is the same. There are some questions we would ask related to intellectual disability, special education, and false
Okay,
confession.
all right, yeah.
That we would ask in the guilt phase that are different from the mitigation questions, but
Okay, we'll just kind of do what we did before. Now, let's say hypothetically, we give it, excuse me, it gets to the jury tomorrow, and Judge Costanzo needs this courtroom, I think, Friday. Of course, we could be here while the jury's deliberating. And let's say the jury comes back, and we do have, say Friday, hypothetically, and we do have to have penalty phase. I know of no rule or reason or rhyme or reason that we couldn't have a 1 or 2 day continuance if necessary, to begin the penalty phase.
If there is going to be a cessation, that is the best point to
I
have
think that
one.
would be the best point. That's the most logical point.
Yes.
Yeah, if indeed we get that far, and so that's what I'm kind of thinking. I don't want to
And you know,
wear out our welcome, as they say.
we're not real familiar with facilities here, and I don't know, I'm just throwing this out there, I have no idea. But the hearing room next door, does it have record capacity?
Is it the same as this? I know that Judge Costanza was doing some civil matters. What I'm asking about, let's say the jury comes back with a question, and we, have to address that out here. Would it still be on the same record that we do it in there? Well, I don't know that we'll need that or not.
It's a large room, that's all I knew, it is a large, it's larger.
Is that something we could
Larger.
use, if we have to, we could talk to Judge Costanza about coming in here for a few minutes to see. But, yeah. I haven't even seen the room myself, but I know Judge Costanza was doing some civil matters.
It's larger than our courtroom C. Now, it doesn't have a jury box, but
Yeah.
it is larger than our courtroom C.
Okay,
It
okay.
is bigger.
Significant.
Well, I think we could, that's encouraging. We might have a way of just, working things as we go. But, and again, like I say, I know of no rhyme or reason why we couldn't have a brief continuance if necessary before beginning, if we get that far, the second stage. So that's what I'm thinking. I'm trying to make room. Like I say,
At that stage, we would have no objection, but again, that still means we would have to all come back here to this courtroom, even with the continuance, and hopefully that wouldn't conflict with Judge Costanza's.
well, that's what I was going to talk to him about,
Yeah.
about
I
date,
just offer.
picking a
for-
date, picking it,
Yeah.
that kind of thing. Or it may be that, well, we'll see how it goes. But anyway, yeah, I'd like to work with him a little, or a lot, and like I say, not wear out our welcome here.
And I know we're kind of getting the cart and the horse all with jury leaving and litigation now, but we also have a guilt innocence phase for the gun charge and a guilt innocence phase for the PFO, which would come in between there somewhere. Just wanted to remind the court.
That charge was severed. I thought that was severed in the sense that it did a different trial.
Okay.
I
Sure.
thought it was just gonna be like quadricated, but what was your impression? Are you gonna?
We're not gonna have two trials now, are we? I thought that was gonna be severed in the nature of another trial,
I think it's just severed.
the gun count.
Your Honor, it doesn't matter to us. We simply want to get through with this.
I think it seems like that make more sense because it gums it up with this,
Right.
and you're gonna confuse.
Now, the penalty PFO.
That has to come
but
last.
Here's where the issue would come.
That has
I
to
think
come
this-
last.
This may be what they're talking about. I don't
Okay.
mean to argue for them, but you don't want to have any issues with consecutive, concurrent, anything like that, given that you try that case at a later time. It was pending and charged while this case, I don't even know if I can go through that in my mind right now.
We're gonna have to talk about a little procedure on the PFO, the consecutive concurrent business, because consecutive concurrent is meaningless on capital. You don't deal with it on capital.
Right.
But at the same time, if anything, you could have the part reversed, and it seemed to me like PFO would be a tail end of just about the tail end of the proceedings.
Yes, Your Honor. And then you
You'd
get
end up
into-
with two. You could possibly we'll have two penalty phases.
You could get into prejudice with
Yeah.
the firearm after they're made aware, and if it's before the initial penalty, I don't
Yeah.
know. We're open to anything.
Well, I'm
I just
looking at
wanted-
two. I'm looking at two penalty phases right now.
Okay.
One overall without the PFO, and then one with the PFO and and a jury decision on consecutive concurrent on the, just on the B felonies.
Right.
And so that's what I'm thinking is a possibility. But they have to be segregated.
Yeah, I just didn't want us to forget about it. I mean, I know we're gonna have scheduling issues, but while we're making a schedule, I thought
Yeah.
I should bring it up.
I was
Sorry.
trying to forget about
Muddied the water,
I was trying to forget about
mixed it all up,
it. So,
made it a mess, but.
Well, if we don't do it now, Your Honor, we're gonna have to wait until the next Harlan County jury pool
that's what I think.
to do it, because
Yeah.
we'll see.
And that may be the case. I have to do that. Okay.
Might get this.
I think we got a load to deal with now, and to keep orderly and
Yeah.
separate now. All right. So, are you ready?
I believe so.
Okay.
Literally more than that, okay. It's like, what's really going on?
Okay.
There's a written statement.
All right, man. Yes, ma'am. Come on up. What's your name, man? Ava Crow?
Yes.
How do you spell your last name, Miss Crow?
C-R-O-W.
Ava.
Well, I think he said he handed
Okay.
this one. Like the-
Is it Doctor?
This
Crow?
is-
Would you raise your right hand, please? Do you swear or affirm any testimony you give us today will be the truth, the whole truth, and nothing but the truth?
I do.
All right, I'm going to ask you to have a seat over here in the witness stand, and if you will speak loudly and clearly, that's a little flat microphone in front of you, so we can hear you.
And then start again.
And,
So that we have hours on the record to, or do both of them at the same time.
okay, Ms. Karen, she's sworn,
Thank you, Your Honor.
and what I suggest we do is like we did before, get qualifications in, what she's looked at, all that stuff, and then go through your avowal, and then we'll move on to mitigation. Now, at some point, if we get to that stage, I hope somebody's got a video editor.
Right.
So
We can cut
because
this beginning
we're gonna
chunk
have
out.
to slice some stuff out, especially in the last testimony, Dr. Fabian's testimony, where we were all talking, discussing, there was cross-examination in the middle. That's gonna have to be edited out.
Your Honor, worst case scenario, we might be able to fast forward, pause, and then play.
Okay?
Yeah, there's a point in there where he repeated some of the first findings in the mitigation portion.
Yeah,
so I
but
think
you'll
we-
want his qualifications and all this stuff he added first.
That's true. Yeah, we
You
can
know,
replay that.
you'll want the
portion.
jury to hear all that. So it's the middle stuff that's gonna happen.
And at what point, Your Honor, do you want to note our continued objection?
I thought I would
To
just start that right now.
what?
To the guilt phase, which you've already
All right.
overruled her motion, but we just. we
We're
have to-
we're gonna do, I'm sustaining your objection to the testimony about to be heard as in the guilt phase, but the guilt phase stuff is going to be heard by avowal now, and then we'll have a break point. You'll get to cross, then we'll have a break point and move like we did before for the mitigation. And then the first part will have to be edited out except for the qualifications.
Could I suggest a break and pause after qualifications?
That'd be a good idea,
Just to help us.
where we got a blank space there to go to, yeah. Good. Okay, we should have thought about that earlier, I guess. All right, Ms. Kim, you may proceed. And this is by avowal.
Yes, this portion is by avowal.
Mhm.
Ms. Crowe, could you state your name and any titles for the record and for the jury, please?
My name is Ava Crow. I guess I go by honorable. I'm an attorney.
And could you,
Let me correct something. This part is not by avowal. We're going into her qualifications and
Right.
things she's looked at. Then let's take a record break and then move, and that part will be by avowal.
Could we start all over then, Your Honor?
Yeah, let's just
just
start all
re-swear
over.
her and we'll
Yeah.
start from
Go ahead.
that point on?
We're trying to, electronically, we're trying to make this work so it won't be a nightmare, okay? Okay.
Your Honor, has Ms. Crowe been sworn in?
Yeah, I did swear in.
And Ms. Crowe, could you again state your name for the record?
Ava Crowe.
And you could go by Honorable Ms. Ava Crowe?
I never am sure about the title of that, Esquire, something, yes,
You have a Juris Doctorate, a law degree.
correct.
Do you have any other, or could you describe your educational background?
Yes, I graduated from University of Kentucky. I'm sorry, my undergrad was from Western Kentucky University, and then University of Kentucky Law School in 1978.
And what is your professional experience?
The last, since 1981, it has been in special education in a variety of settings. For about 10 years, I worked for a state government agency, Protection and Advocacy, and their mandate was to protect and advocate the rights of people with disabilities. I did all of their special education litigation for the 10 years I was in that office. I was a supervising attorney for that office. I went from there to the Office of Education Accountability, which is located in the legislature. They have a different mandate, and it was to investigate complaints about local school districts. I handled the special education complaints for that office for about 10 years. I then worked for the Kentucky Department of Education, was an assistant general counsel there, oversaw the special education complaint process and administrative hearing process that they were responsible for. I retired from state government at that point, began consulting, worked for about a year in the state of Ohio under a grant that was funded by the Ohio Department of Ed, and that was to evaluate education programs in the county juvenile detention facilities, prepare a report that later became the basis for some legislation in Ohio. I went from that to a contract job working as a subject matter expert for litigation that was pending in the Southern District of Ohio with Judge Marbley. The juvenile correctional facilities in Ohio had been sued, a settlement agreement had been reached, and for the next 5 years I monitored the special education and regular education programs in the juvenile justice facilities. And that's the bulk of my work.
So I'm going to ask that you be allowed to give testimony about the special education services provided to Shelby Shell. Are you familiar with, or did you review records in preparation for your testimony today?
I did.
And what sorts of records did you review?
There were roughly 2,000 pages. They involved some school records from both Harlan County and Jackson County, as well as what's called an individual education plan from Christian County, where Shelby received services, I think, very briefly. I reviewed some juvenile court records from the Harlan Juvenile Court, residential, school, and living records, unit records from extended care programs he was in. Ramey Estep home, the Barnabas home. He was at Cumberland Hall, which was a long-term juvenile facility down in Christian County. Those records, and I guess that's the bulk of it.
And those facilities were, I want to say, Cabinet for Health and Family Services type facilities, is that?
Yes, they're long-term residential treatment facilities that the cabinet uses for children in their foster care system who need more structure than, say, a foster home provides.
And in reviewing Shelby's special education records, did you find that he qualified for special education services?
Yes, he did. There was an evaluation that was started when Shelby was in the first grade. That process starts by someone seeking a referral on a student, and his first grade teacher had Shelby for about 2 weeks and started that referral process on Shelby.
And in what areas was he considered to be in need of services?
At that time, the terminology is different than the terminology you see in the psychology field or the psychiatric field. The term used at that time was educably mentally handicapped, EMH. So that is how Shelby was classified. He also was identified as needing services of a speech therapist. Speech and language skills are divided into 2 areas, expressive and receptive language. Shelby was in the 1 percentile for receptive language when he was tested for special education. And that means that he was in the lowest 1% of the population in terms of his receptive language skills. So he got services from a speech and language therapist, also services as an educably mentally handicapped student.
I apologize for delay. Let's see. So part of your review included what plans were in place for Shelby to address those deficits or areas of need.
Right.
Let me step back one question and just say, is educable mentally handicapped equivalent to intellectually disabled?
Yes.
In today's terminology?
Yes.
Okay. And did you review records that included IQ assessments?
I did. That is the special education law requires evaluations of students every 3 years. Shelby's evaluations did not happen in a timely fashion, but there were a few in the file. And yes, those for a child who is labeled educably mentally handicapped have to include an IQ score.
And do you recall approximately where his IQ score fell?
Yes, it was fairly consistently somewhere below 70. I think his first one was 64. There is a standard deviation that allows a little bit of flexibility in looking at those scores. He had one outlier, excuse me, that was above 70, but by and large they were 70 or below.
I'm going to ask about placement history separately. I want to ask you about intellectual disability and how it would affect a child's behavior in a school setting, and specifically as regards Shelby Shell. So did you observe in those reports, or is it your opinion that Shelby would have had deficits in other areas, not just academically, but socially, behaviorally in the school system?
Absolutely, that is a factor in intellectual disabilities. It's not just a measure of academic skill, it's a measure of how a student or a person functions in the world. So you also look at what they call adaptive skills that should be taught to children with who are EMH. intellectually disabled.
So some of those skills could his deficits, I'm going to say intellectual disability because that's what I've been using,
Sure.
affect his ability to arrange events in a logical order?
Yes. Folks with intellectual disabilities have, I mean, it's a given by the term, a disability that affects their intellect. That means they're slower and they think differently than folks with an average IQ. They don't grasp things as quickly. If you're talking about sequencing events and behaviors, they will have deficits in those areas. And those are areas that a student can be taught to improve in those areas if an IEP focuses on that student's adaptive skills. Focus on teaching Shelby, for example, proper in a classroom, proper hall behavior, proper bathroom behavior. Teach him with direct instruction, use role playing, use techniques that are not typically required for folks with average intelligence. So yes, he would have problems sequencing events. He would have problems foreseeing consequences. If you think about a child with Down syndrome who might have a match, toss it in a trash can, and then 10 minutes later when the trash can flares up, not be able to connect the match behavior with the trash can behavior. That's what you would expect to see in a child with intellectual disabilities.
In addition to that, you mentioned speech issues. Now, is it your testimony that he could have received speech therapy for receptive language problems?
Could have and should have, and that therapy should have been generalized to the classroom setting so that the teachers knew how to work with that. This is an area where Shelby's program was really lacking. When you look at receptive language, what you're looking at is, among other things, a child's ability to understand questions. A person with receptive language problems will have difficulty with plurals. They'll have difficulty with tenses. Because questions get formatted differently than statements, they'll have problems with questions. What gets asked will not necessarily be what they process. You can work with that. Speech therapists know how to work with that. And what should have happened was those strategies should have been identified. It should have been generalized to his other teachers, and it should have been intensive when you're in the 1 percentile. Shelby's speech services were intermittent. I know from the records he got no speech therapy when he was at Cumberland Hall, which was about a year. There were big gaps in his speech therapy services when he was in the Jackson County school system. He didn't get speech therapy for the whole first semester. So, for an issue that can so affect the way a person is being perceived and the way they perceive the world, that is egregious.
I'm going to ask more about the services he received in placements further along in questioning. Okay. Thank you for getting into that a little bit. I wanted to ask about his understanding and reception of language when it came to idioms and sarcasm. Those are really two separate questions, but that's what I wanted to ask about next.
Typically, because a student with severe receptive language problems doesn't process what is being said to them, Yes, idioms could be very difficult. Sarcasm could be very, very difficult. Most people would know it was sarcastic if I said you were an idiot, but a person with receptive language issues could well think I meant it.
That's just a word that reception I needed some definition for, so
Sure.
thank you. One of the other topics related to intellectual disability is perhaps gullibility or wanting to please others. In your review of the records for Shelby Shell, did you find any examples or history of gullibility or behavior related to his intellectual disability that led him to follow along with others?
Yes, Shelby, and it's a thread in his life, I think, certainly his school life. A lot of his behaviors were identified as seeking adult attention and seeking peer attention and friendship. So Shelby would sometimes do or say, and this is throughout his facility records, it's in his evaluations, it's on his school report cards. Could be talked into doing things, could be led into doing things, tried to do things to be accepted and be a part of the friendship of peers. For example, there was an instance where he burned his arm trying to impress peers with how tough he was. An example of jumping in the deep end of a swimming pool even though he couldn't swim. And it was to attract, the belief of the staff was it was to attract attention and friendship.
So is that typical, or is that a symptom of the intellectual disability to put oneself in harm's way to gain friends, to be socially acceptable?
If you're not taught appropriate adaptive skills to develop friends, you develop maladaptive skills if you have an intellectual disability. So yes.
And speaking of addressing those adaptive and maladaptive skills, you mentioned a year gap and a semester gap. When there are gaps in services, can there be regression in his ability?
Absolutely. Absolutely. Continuity in the special education law is critical. And all the provisions in that statute talk to maintaining continuity.
I'm going to ask about his high school diploma and what someone should understand about that diploma given his intellectual disability and his history of special education. So could you explain what how meaningful that diploma is for Shelby?
Shelby got his diploma from Ramey E-Step, which is one of the residential facilities he was at. And he had been there a year. He went in May of '99, and he graduated in June of 2000. When he went in, he would have been 16 years old. And he went in with 4.5 school credits, high school credits. He graduated with 20.5 high school credits a year later, which means he got 16 credits in a calendar year actually in 2 semesters because they didn't have summer school. 2 semesters at Ramey E-Step. He got 16 high school credits, which at that time was impossible to do. Credits were given in part by what they called seat time. You had to spend X amount of hours sitting in the math classroom, in addition to accomplishing other things. And it was physically impossible to get 16 credits in 1 year. I think Ramey Estep thought a diploma was valuable in the workforce and was generous with them, but it did not work to Shelby's benefit.
So his diploma is not recognition that he's achieved a cognitive or intellectual milestone. He's
Oh,
still
no.
intellectually disabled, even though he was given a diploma.
Absolutely.
I'm going to ask that we break for a moment. Okay. Ms. Crowe, I'm going to ask you now about the interplay of intellectual disability with false confessions or Okay. Ms. Crowe, I'm going to ask you now about the interplay of intellectual disability with false confessions or incredible, unbelievable statements that somebody might make because of that intellectual disability. You had spoken earlier about receptive language issues. Would an inability to understand sarcasm or idioms affect someone's perception of a conversation, specifically someone with an intellectual disability? That's the question. So would their ability to understand sarcasm and idioms affect their perception of a conversation, as to whether they thought it was a sarcastic conversation, a serious conversation, a joke?
Oh, absolutely.
Okay.
Absolutely.
So it would be possible for Shelby Shell to make a statement that seemed serious to others but was a joke to him.
Certainly. One of the areas you see problems with folks with receptive language issues, especially severe ones, is cooperative talk. They don't hit right. They kind of bump into each other. Yes, it's a misunderstanding of what's being heard and therefore how you respond.
And then the second question is about an area about intellectual disability and gullibility, pleasing others, following others' leads. Would it be a symptom of an intellectual disability for someone to make an outlandish statement to get the approval of peers or others?
Yes.
And in your review of the records, did Shelby Shell make that type of statement to gain the approval of peers or others?
He certainly made those kind of statements, and it appeared that often, because they were made to adults, it was to get the attention of the adult.
And would admitting to a crime be harmful to Shelby Shell? That's maybe not even a question.
What was your question? I couldn't hear you.
Would admitting to a crime be harmful to Shelby Shell?
Yes, certainly.
And has he in the past done things that were harmful to himself to gain the approval of others?
Yes,
And is that a symptom of intellectual disability?
yes, doing what needs to be done to meet your goal when you have not been taught the other more functional, appropriate ways to handle that.
I'm going to ask that we pause there.
Well, I think that there'll be cross at this point, and then we'll pause after the cross, so we have another break in the record, right?
Do you want to put on the pause?
Just a couple, Your Honor.
All right.
Ma'am, you testified that he would say things and he would perhaps say things that weren't true in order to get the attention of adults.
Adults and at Ramey E-Step also of other people his age, yes.
And when you're referring to that and what you saw in the records, you're not talking about anything in the last, since 2013, are you?
That's correct.
You're talking about those records that were, fair to say, childhood or school records.
Yes, up till he was 18.
And you're not testifying that he would lack the intellectual ability to commit murder, are you?
Can you repeat that? Is there a double negative there somewhere?
Would someone with the ability that Mr. Shell has, that you've testified regarding his records in school, he would still have the ability to commit murder, isn't that correct?
Without going through every element of murder, I don't know that I can answer that.
Kill somebody.
I don't know how much intellect it takes to kill somebody. Most people could
That's
kill
all.
somebody.
Thank you, Your Honor.
Okay.
Okay. We want to pause. Is that it? We want to pause here?
I think that concludes the portion.
At the bend. Okay, let's pause on the record. We've got a break. Okay, we're back on the record now. Go ahead.
I'm just going to sort of title this section. I'd like for you to speak to the jury about some of the opportunities missed in Shelby Shell's educational records. I know we've got this really nice graphic, and I'd like to submit it as a demonstrative exhibit only for the mitigation section. Yeah, there's one there. You can have one. I did get that out. Can we put this on the Elmo while she's speaking?
Elmo, I suppose we could.
Okay, I'll find my approach.
bring that where she can see it? Okay? She need to see it.
She'll have it right in front of her, I just want to make sure it gets into the
All right. Okay.
record.
Will we ever be able to play back this through that for the
That,
jury?
ideally, that's how
Yeah,
we
all
would
right,
do
okay.
that. Okay,
Camera on?
so is it on? When it's on, we'll start.
You switch over, Miss. It.
Waiting for the TV. I'm feeling better. I'm not as cold
It's
as I
better than
was.
it was, but I don't feel like I'm trying to kick in again.
Then it says we're on over here. It went to document camera, but it went back off.
Because we still have stuff plugged in.
Any suggestions?
Green.
Go back and go again, Missy.
Redo it again. Take a recess. Should be on there.
Let me suggest this, perhaps when the jury's here, we'd have Elmo working or publish it to the
Yeah,
jury,
just-
something like
they
that.
can follow along.
Just don't worry with it today.
Oh, no,
Well, we have
Yeah, we took this.
an idea what's causing it.
It's not on.
So, I think, should we go ahead?
Try it again. I'm sorry.
Okay.
We're giving up on the Elmo for right now. So, what I'd like to ask first is what does the Individuals with Disability and Education Act, I think that's the right words, require for educational providers to do for students who we would call special education students?
The statute is expansive and has a number of requirements in it. The overarching requirement is that students with disabilities get an appropriate public education, and that the school, with very limited exceptions, has to provide all services necessary for that student to obtain an appropriate education. So there is a requirement for complete evaluations of a student with a suspected disability, and then reevaluations every 3 years, because kids change as they grow, obviously. There's a requirement to provide a multitude of requirements that ensure consistent services are provided throughout the student's career. There's a requirement that the services be individually determined. So in Kentucky, we have what are called ARCs, admission and release committees. They're called IEP team meetings in some other states. It's the teachers, the child's parent or representative, a school administrator, and they're required to sit down at least once a year, and more often if a kid starts experiencing difficulties, and draft up a written education plan for that student the next year. For students with behavioral issues, there are very explicit provisions requiring either goals in the education plan or what's called a BIP, an education or a behavior intervention plan, and that those be monitored. There's a requirement that transition services be provided for students when they reach age 14. There's got to be consideration of that. By the time they're 16, they should have in their IEP a coordinated set of activities to transition them to adult life. And those are kind of the big areas that I found problems with in terms of Shelby's program.
So, I guess, we have a graphic, and I'm going to start at the sort of the top of the graphic as a topic. Was Shelby Shell entitled to high school education up to age 21 as a special education student?
Yes, in Kentucky, the law is explicit that a special ed student receives educational services to age 21 or until he receives a public school diploma that is a diploma. Ramey Estep at that time, it appeared, was operating a private school on its own grounds. So that would not disqualify Shelby from educational services to age 21.
So potentially he could have re-entered the public school setting for appropriate vocational or transitional services until he was 21.
Absolutely, and should have.
But it just didn't happen.
It did not happen. The diploma got issued at Ramey Estep. I believe the adults in his life kind of dropped the ball. And he had almost 4 more years of education that he was entitled to that could have been vocational. Could have been the adaptive skills to help him learn how to handle social issues better.
He could have learned to write a check, for example.
Absolutely. Complete a job application.
Yeah. The next category ties into that. Even if he didn't get the full education to 21, he was eligible for transition services.
Yes, and that would be a part of his services till he was 21. But the Admissions and Release Committee, the IEP team meeting, is required to call in community providers. With somebody like Shelby, probably vocational rehabilitation would become a member of his ARC. They can provide assessments, they can provide job training. They could pay for speech therapy if his receptive language turned out to be a problem, which it would have. They can provide job coaches at a work site if that's what a student needs. So, yes, all those services could have been accessed for Shelby up until age 21 and voc rehab on beyond that.
And that transition planning could have started fairly early for him. I'm just referring to the chart. So
age 14, the school is supposed to start considering it. By age 16, the coordinated services should be on the IEP.
And again, Shelby didn't have any of those services.
No. There was a statement in his Jackson County school records that a 8-week, I believe it was, course in careers would be made available to Shelby, but he was expelled from Jackson County before that could happen. That was as close as he got to transition.
In addition to transition services, Shelby had, let me ask, did Shelby have behaviors in the classroom related to his intellectual disability that needed to be addressed?
Shelby had behaviors often not in the classroom, much more in unstructured settings like the hallway and the cafeteria, as many kids do. Yes, he did have, that's what led to his expulsion, which you cannot expel a special ed student without a lot of procedures. Shelby was expelled from 2 different schools. Those procedures were not followed. even if they had been, you cannot terminate educational services to a special ed student. So he had behaviors, they led to illegal consequences to Shelby in terms of expulsions.
And to address those behaviors, he could have had, I think you called it a BIP, but a behavioral intervention plan?
Yes.
And was he ever provided a behavior plan?
No. Ramey Estep had a plan that was facility-wide so that all the students at Ramey Estep were subject to it. The special ed law requires an individualized plan. And the reason for that is kids do things for different reasons. If Shelby were doing something to get peer attention, you would write a plan differently for him, a plan that would put him in timeout when he acted out, to minimize that peer attention that he got. If he was doing it for adult attention, as Shelby often did, you would first make sure there was plenty of adult approval every time he acted right. Every time he walked down the hall right, you'd make sure there was an adult in that hall saying, "Wow, Shelby, you're doing a great job in the hall today." And if he didn't do a great job, his consequence would be pulling that adult approval back. So he needed an individualized plan that addressed his reasons for why he acted out, and he did not get that.
And if he had had a behavioral plan, it could have addressed some of the adaptive deficits related to his intellectual disability.
Yes, yes.
That's the next line of questioning, is did he ever have a plan that focused on not just the cognitive or academic consequences of intellectual disability, but the adaptive skills, social, practical areas?
In going through his IEP, his individualized education plan for the years that I could obtain it, no, there was never once any kind of work on improving his adaptive skills, particularly those related to behavior. They just weren't there.
I think the next area where it seems like Shelby was missing some of the benefits of being a special education student was consistent special education services and settings. Did he miss educational time, semesters, years, weeks? What was your review of the records? What did that show you?
Yes, certainly those last 4 years he missed consistent educational services or any educational services. When he was in first grade and the teacher requested a special ed eval for him, she requested a couple weeks after school started. They did not complete it until March, and there's a document in his file that shows they didn't actually place him in special ed until the end of the school year, which some school districts did that for a while, tried to do that. So he went that whole year without services. The next several years that have an asterisk on the graphic, I couldn't tell if he did or didn't get consistent services. I do know he had a special education teacher. I do know she provided services. I don't know how consistent they were. When you look at 96, 97, Shelby got expelled illegally in March, and he may have gotten some services after that on homebound that his grandmother may have arranged, but that would have been 2 hours a week of services. The next year he was in Jackson County, again illegally expelled from there, and particularly those 2 school years, Shelby bounced around a lot. He went from a foster home to a facility, to a psychiatric hospital, to his grandmother, to a psychiatric hospital, to his grandmother. He was bouncing back and forth. It's unlikely in some of those settings he got services at all, but they certainly could not have been consistent. The Jackson County folks did not get his school records until he started school in August. They didn't get his school records until January. They had him in the wrong kind of classroom. Classrooms in special education are broken down to a general ed classroom where all students go. What they call resource rooms, where a student may go for a couple or 3 or 4 hours a day. And then what they call self-contained, where a special ed student is in a special ed classroom all day. Shelby was in resource rooms when he was in Harlan County. His records did not make it to Jackson County until January. They had him in a regular education classroom, 28 kids or so. They didn't know where he needed to be, where he was supposed to be. When they got the records in January, they placed him then in a resource classroom, but expelled him in February. So that kind of shot that year. Then the next year he was at Ramey getting his 16 and a half hours of high school credit. He got some special education services that looked like, but not consistent with those he had received in the past. And then, of course, the last several years he was entitled to services. He got none.
And some of the services, like the resource room, would have included a classroom with fewer students to teachers.
Those resource classrooms had caps of 12 students, I believe, 8 to 12 students. A general ed classroom had a cap, I believe, of 28 students.
And sort of finally on the graphic, he was finally evaluated in first grade.
Yes.
And he was due for reevaluations. Did those ever happen in a timely manner?
His next one was a year late. His next 3-year one got started in March of '97, but it was started in Harlan County. He moved to Jackson County. They finished it up, but it was in '98, and they never did a speech evaluation for Shelby at that point, and nor did he get one at any time after that. So there was no effort to identify at that point his level of receptive language.
Is another question. Let me move on from there. These services, were they services that Shelby could request on his own?
No. Now, when he turned 18, had someone told him, yes, he could have then. But there's no evidence. He was at Ramey Estep. They gave him a diploma and thanked him so much for being there, and he left.
So while he was under 18, a parent, guardian, somebody else would have to have sought out those resources, or at least kept up the process. I think that's
legally it would have had to have been his parent. At that time, there's a provision called surrogate parents in the special ed law, but you could not get a surrogate parent, which perhaps his grandmother could have served as, if the mother is available, even though incapacitated, even though unwilling to participate. The fact that she was there and could be located meant she was the one that needed to do it.
if he had been in the custody of the cabinet, had been a ward of the state, a foster child, somebody other than his mother could have signed him up for special education services?
It could not have been the social worker, but several counties figured out how to work around that provision and typically would get the mom to sign a document saying that the social worker could. So yes, there was a way for that to happen, and it did not happen for Shelby.
So even if his mother lost custody of him and the cabinet took custody of him, it would still have been difficult, although there was a workaround, for somebody else to initiate special education services.
Yes.
And is there a point where the special education services are started by the school and the school is just supposed to keep them going, or did they have to keep going back to the mother?
No, once they get started, they do not need parental permission on down the road. They can proceed without her, but, and that happens often. The problem is at those IEP team meetings, the ARCs, the student's not really in a position to represent himself either, just by virtue of being disabled, intellectually disabled. So there's really nobody there representing the child.
So after Shelby was evaluated in first grade, the school systems could have kept up his special education
Correct.
services without additional releases from his mother.
Correct.
They
And
had
they-
him sort of in the radar.
They did in some of those years, yes.
But Shelby, as a fourth grader, as a seventh grader, wasn't going to be able to ask for those services.
Correct.
Is it fair to say that there are adaptive deficits, vocational skills, practical living skills that Shelby doesn't have now that he could have had if appropriate services had been provided?
Yes, the failure over his school career to provide him with adaptive skills is really dismaying. Where Shelby could have been had he learned how to socially interact with people, learn how to express his emotions, learn how to deal with frustration, he could be in a very different place.
That's all the questions I have for you.
Cross-examination.
Would it be fair to say that your testimony here is that Mr. Shell was cheated out of a good education or education resources?
Yes.
And who do you blame for that?
I wouldn't say cheated, I would say deprived. I don't
Deprived.
believe there was bad intent on the part of teachers. I do not believe there was bad intent on the part of the Ramey staffs that pushed him through. But the outcome is what it is. And in terms of assigning blame, it's a tragic circumstance. He came from a difficult family situation. He had, as I understand it, a loving grandmother, but she was a grandmother. As the school failure started to grow, they were less able to help Shelby and manage Shelby. I'm not comfortable saying somebody's to blame, though.
But someone's at fault. You're willing to say someone's at fault.
Yes,
You can say someone's at fault.
I can say the system failed him.
And there's fault.
There's damage.
Pardon? I couldn't
That was
hear.
asked and answered, just asking your phone.
The question was, can you say there's fault?
I can say there's damage.
There's damage. Damage done by who?
The system's failure.
And what system?
The foster care system that has a zillion kids and not enough placements. The education system that doesn't have enough money to serve the kids it needs to serve in the way that the law intends for them to serve them. I don't know what more to say.
What year did Shelby Shell receive his high school diploma, which you said he didn't necessarily earn, but nevertheless, what year did he get a high school diploma?
It was June of 2000.
June of 2000. How old was he then?
He would have been 17.
How old was he, what year did he turn 18, an adult?
2001,
2001.
yes.
How did the system fail him between 2001 and 2013? From the time he was an adult to the time 2013 he was arrested for murder?
I can speak to 2001 to 2004, which is, his educational career, and when that would have ended. That's when I quit reviewing documents.
So after 2001, are you saying you can't speak to what happened after 2001, between 2001 and 2013?
I can speak 2001 to 2004, and I believe that
And that's a period of time where he's turning 21?
Correct.
And you say, had he or someone on his behalf asked or insisted that he attend some sort of vocational school or some sort of schooling, he could have been provided public services from the state. Is that what you're saying?
Yes.
So after he reached 21, the state had no responsibility to continue with education. Is that what you're saying?
Well, actually, there's a concept called compensatory education in special education law, and for students who have been deprived of an appropriate education, they have a claim for compensatory education. And we have students in this state who have gotten educational services beyond the age of 21 because they did not get appropriate services prior to age 21.
You've reviewed all of these records, education records.
Yeah, all that were
that you
available, yes, sir.
mentioned that were available.
Yes, sir.
You didn't review any records after age 18?
21. Well, yes.
Educational records.
You're correct. 18.
After age
After
18.
he graduated.
18, which was in 2000. Don't let me put words in your mouth. You've got the chart there. He turned 18 when?
He turned 18 in 2001. Is my math correct? 2001.
2001.
Yes.
So after 2001, the state had no obligation to provide him, or after 2001, he did not receive any other educational services from the state.
None that I know of, no.
That's all. Thank you.
Thank you.
Any redirect?
No, Your Honor.
All right, thank you.
Thank you.
Appreciate it very much. You're excused. All right, I think that's it for today then. We'll go off the record. We'll see you in the morning.